Hello, I'm William Schabas, and this is a lecture on international humanitarian law. International humanitarian law is a body of law that applies to war, to the conduct of war. It's part of a body of international law that governs war. There are other pieces, and I just want to set those out so that you understand the distinctions. When we talk about law and war, we generally identify two broad categories, what we call the jus ad bellum and the jus in bello. These are Latin expressions. The jus ad bellum refers to the law that applies to the legality of the war itself, whereas the jus in bello is about the legality of the conduct of the war. It's the law in the war rather than the law at the war or about the war. The jus ad bellum, of course, has undergone very significant changes in the last century or so, from a time when it was actually considered lawful for states to go to war to settle international disputes. The First World War is the great example. When the fighting began in the First World War, it was not Germany's attack on France and Britain. It was the attack by Austria on Serbia. It's a kind of revenge or punishment of Serbia for the assassination of Serbia's Archduke at Sarajevo at the end of June of 1914. And when Austria, after failing to extract from Serbia the kind of guarantees and concessions that it wanted, Austria gave an ultimatum to Serbia and said, well, then we're going to go to war. And they went to war, and they fired cannons at Belgrade, the capital of Serbia. And nobody said that was against international law. That was what states did when they couldn't agree otherwise. It was only in the course of the war that people started to think about, and it was the horrors of the war that brought out the idea that modern warfare simply should not be allowed as a way of states settling dispute. The German emperor was contemplated for prosecution for starting the war at the peace conference in Paris in 1919. But finally, the experts at the peace conference recommended that he not be tried for starting the war because they were not convinced that it was both a war crime or a crime at the time, but moreover, that it was unlawful. That it was unlawful, that it was prohibited by international law. But that began a process that then culminated at the end of the Second World War in two dimensions. The first was the prohibition under state responsibility, under international law, of the use of force to settle disputes. And we have that set out in the Charter of the United Nations, Article 2, Paragraph 4. And you have the text there in front of you. And at the individual level, in the recognition that those who participate in a crime of aggression as initiators, leaders, and so on, can be punished under international law. Today, we call it the crime of aggression. It's Article 8 bis of the Rome Statute. In 1945, it was called crimes against peace, and it was prosecuted, and people were convicted at Nuremberg for crimes against peace. The jus in bello is different. The jus in bello is not about deciding who's right and who's wrong in the war. The jus in bello is may be violated by the people who are victims of an unlawful war, or people who are fighting in self-defense or fighting to liberate themselves from colonialism. They may be entirely justified in using force, but they're prohibited from breaking the laws that apply to the war itself. And here we can make the same kind of distinction that I've made with the jus ad bellum and the jus in bello. We have the law of state responsibility that we will call the laws and customs of war, or the law of armed conflict. And states are responsible for respecting those rules of international law if they're engaged in an armed conflict. And the individuals who may violate these rules can be prosecuted for war crimes. The Rome Statute of the International Criminal Court also governs war crimes, and it has a detailed codification, really the most detailed one, although war crimes were also prosecuted at Nuremberg. So a distinction between the jus ad bellum, the use of the war itself, and the jus in bello, the conduct within the war. Let me say a little bit about history. Some of you may recognize this painting, or at least you'll know what it's about. This is taken from the Iliad, Homer's famous Iliad. And there is Achilles, who is riding on his chariot. He's just slain he's the Greek hero, and he's just slain the Trojan hero, whose name is Hector. He's the son of King Priam. And he takes Hector and ties him to the back of his chariot and does circles around the walls of Troy, dragging the body. There's the sense that he's outraged. He's violated the laws of war. He's committed indignities to a fallen warrior who he should have respected. Achilles does it because he's very angry and bitter with Hector, because Hector had killed his best friend, Patroclus, somewhat earlier. But that's not a reason to violate the laws. He's not justified in violating the laws and customs of war. And so we have this sense in the Iliad that he's broken the laws and that he should be punished. Of course, there's no international criminal court at the time of Homer and the Iliad, but Achilles eventually is punished. He's punished by the gods for his wrongdoing. We can find other examples about how the laws of the conduct of the war have evolved and developed over the centuries. Here's a reflection of it, slightly more recent, from one of Shakespeare's plays, Henry V. Henry V deals with the Battle of Agincourt, the battle between the French and the British in the 15th century. And there's a famous scene towards the end, after the battle, when Llewellyn, who is the Welsh captain in the British Army, speaks about the French who had murdered the boys who had been part of the British Army. It says, killed the boys and the luggage, 'tis expressly against the law of arms. And Gower, the English captain, answers, 'tis certain, there's not a boy left alive, and the cowardly rascals that ran from the battle had done the slaughter. So besides, they burnt and carried away all that was in the king's tent, wherefore the king most worthily hath caused every soldier to cut his prisoner's threat. So there are lots of violations of the laws of war in there. First of all, the French may be faulted for killing boys who were apparently not combatants, but were behind the lines, and therefore not actively participating in hostilities, perhaps. There's also a violation in modern day times of having boys in the army at all. They would be called child soldiers. And then we see in the second part, when Gower responds, yes, it's a violation of the laws of war, says Gower, 'tis certain. And then he praises King Henry V, who decided as some sort of revenge or punishment that all of his soldiers were to cut their prisoners' throats. So that was written by Shakespeare at the end of the 16th century. There are many references throughout Shakespeare when he talks about battles to laws and customs of war. Well, sometimes we'll talk about that we use the label chivalry, which comes from the Middle Ages. The knights had their code of chivalry, and they had rules that they had to respect during the conduct of wars. It's only in the 19th century that we start to actively codify the laws of war. And there are many sources. I'm only going to touch on a few of them. There was a famous code that was drafted by by a law professor at Columbia University in 1860. And it was proclaimed by President Lincoln during the Civil War as a code of conduct that should be applicable. Well, that was within a civil war within the United States. The first manifestation in international law of codification was the Geneva Convention of 1864. And the Geneva Convention of 1864 had as its main purpose to protect medical personnel on the battlefield. So it said that they would wear a red cross to identify themselves, and they were to be immune from attack as long as they were only fulfilling a medical function. Then later in the same decade, we have the St. Petersburg Declaration, whereby it's declared that the use of hollow-tipped bullets, what we sometimes call dum-dum bullets, was prohibited. And it sets out, it's the basis of a more general prohibition of weapons, of the use of weapons that are likely to cause unnecessary suffering or superfluous harm. The problem with a dum-dum bullet is it explodes within the target. And so instead of just taking the soldier out of action, which is what any bullet should be able to do, it actually mutilates the body in a terrible way, and therefore the damage is superfluous or causes unnecessary suffering. At the end of the 19th century, there's a famous conference convened at The Hague to codify international law dealing with armed conflict. Several treaties are adopted. Some of them deal with the waging of war. They deal with the jus ad bellum. They deal with issues like neutrality and so on. But one of the conventions, Convention number 2 of 1899, deals with the laws and customs of war. And it sets out a detailed list of rules. There's a second Hague Convention in 1908 that largely repeats what was in the 1899 convention in terms of the laws and customs of war. And the rules that are there in the convention will eventually be referred to much later at the time of the Second World War as a source of violations that can provide a basis for justifying prosecution of people for violating, for committing war crimes. And even more recently, we still refer to the Hague Conventions. You will find judgments of the International Criminal Court and of other international criminal tribunals that will make reference to the Hague Conventions for the purpose of understanding the scope of modern day war crimes. Following the horrible use of gas during the First World War, the so-called gas protocol is adopted in 1925. And then at the end of the Second World War, we have 4 Geneva Conventions adopted in 1949, and they are further codified in 1977 with the adoption of 2 protocols. The Geneva Conventions are somewhat distinct from the Hague Conventions, and we will often talk about Hague law and Geneva law. Hague law is more concerned with and directly addresses the actual conduct of the war, of the hostilities, whereas Geneva law deals with the victims of armed conflict. So there are 4 conventions adopted in 1949, and they are distinguished, the 4 of them, by the nature of the victim that is being protected. The first convention is with the wounded on land, in land battles. The second is with the wounded and the drowning in war at sea. The third deals with prisoners of war who are combatants but who have been taken prisoner. And the fourth deals with civilians. So the first 3 are dealing in effect with those who have fought but are no longer able to fight. We'll use the French term, hors de combat. They're no longer participating and no longer can participate in the conflict, either because they're wounded or drowning or prisoners. And then the 4th convention deals with civilians. And essentially, because these conventions and all of this law I've described is dealing with international wars, with the international armed conflicts, the 4th Geneva Convention is essentially dealing with situations of occupation, of people who have come under the control of one of the parties to the conflict. And there are detailed rules that have to be applied. And I'll have more to say about that in a few minutes. I mentioned the protocols here, just to finish with our 2 protocols of 1977. The 2 protocols are distinguished not by the nature of the victims, not by the distinction between people who are no longer combatants and the conduct of hostilities, which deals to a large extent with people who are combatants. But the distinction now is made between the nature of the conflict. So as I've just mentioned a moment ago, the earlier treaties until the Geneva Conventions dealt essentially with international wars. And it was only in the 1949 Geneva Conventions that there was even just a hint that they would begin to deal with non-international armed conflicts or civil wars. And that was to a large extent motivated by concern about violations and atrocities that had been committed during the Spanish Civil War, which preceded the Second World War, which began in 1936 and finished in 1939. But there's only one provision in each of the 4 Geneva Conventions, and that's very vague in general. It's the same provision, it's Article 3. And so we refer to it in international humanitarian law as common Article 3, because we have the same article that's common to the 4 Geneva Conventions. But that's it. But by the 1970s, it had become apparent, and this is because of developments in the use ad bellum, remember that distinction, because the use ad bellum had been so successful following the Second World War that there were very few international wars. International wars were largely a thing of the past. They were prohibited by law, and they happened very occasionally. It's still the case today. We've had no world war or anything resembling it since 1945. And we've had virtually no acquisition of territory by aggressive war or annexation, a little bit, but not much, not compared to the period before 1945. And so it was becoming increasingly clear into the 1970s, 1960s and 70s, and especially because of the Vietnam War, that wars were going to be largely internal wars or civil wars. And so the 1977 protocols, there are 2 of them. The first one deals with international armed conflict, and the second one deals with non-international armed conflict. There's an imbalance between them. That's still present. The second additional protocol, which deals with non-international armed conflict, is considerably shorter than Protocol 1 dealing with international armed conflict. It's been much more important, the shorter one, than the longer one. And what's the explanation? Well, states are very uncomfortable, as a general rule, with allowing international law to intrude into disputes within their own territory. And their view often is to say, it's not an armed conflict. It's not a non-international armed conflict. All that we have going on here is some criminals. That was largely the case with the United Kingdom during what amounted to a form of civil war in Northern Ireland in the 1970s and 1980s. But the position of the British was, I think, fairly consistently that international law didn't apply, and that if there were violations, they would be dealt with under the criminal law applicable in Northern Ireland. Of course, there are some aspects of the 2 protocols that are significant, but there are important differences. I think probably the main difference between the 2 of them is that the notion of occupied territory doesn't really apply to a non-international armed conflict. So the idea, if you have a civil war going on and the rebels capture some of the territory, why they're the government. And they may end up winning the war, and that wouldn't be a violation of any use ad bellum either, because they're not conquering any other country. They're not conquering territory. It's simply a violent conflict within the country that may lead to a complete change in legal regime and the change of government.